Hey, this is Tulsa criminal defense attorney Stephen Cale. I'm going to talk to you today about how much you should tell your criminal defense attorney. Now, for many of you, if you've been charged with a crime, whether you're guilty or innocent, or even if you've just been arrested, or not even arrested, something's happened, there's been some kind of event, you're scared, you think the police are going to be involved, there might be an investigation. All of that can be really nerve-wracking. Sometimes you need an attorney even before there's an investigation, or before there's an arrest, or before there's a charge. So, again, all of that can be really nerve-wracking. And if you are charged, it can be pretty scary when you're appearing in court before a judge or a prosecuting attorney. And sometimes you may not feel like sharing everything to your attorney just because you're scared. So we're going to talk to you about that today. Now, one of the first things I want to get into is really why hire a criminal defense attorney, or really what's the responsibility of a criminal defense attorney? And first of all, think about this. A great criminal defense attorney will, for one, try to protect your freedom. I mean, that's the first thing that a criminal defense attorney is going to try to do for you, keeping you out of jail in the meantime if there are charges, keeping you out of jail if there aren't charges yet and there's just a criminal investigation, or if somebody has been put in jail, trying to get that person out of jail on some kind of bond. So that's the first thing that a good criminal defense attorney, or really a great criminal defense attorney, is going to try to do, is protect your freedom. And then secondly, a great criminal defense attorney is going to hold a high burden to the prosecution. In order for somebody to be convicted of a crime, the state or the prosecution has to prove each element of the crime. That means every part of the crime beyond a reasonable doubt. That's a high standard. And I'll probably talk about that in another article or interview about the different levels of proof. But for criminal cases, in order to convict, it's beyond a reasonable doubt. Very high standard, okay? And so a great criminal defense attorney will want to hold the prosecution to that high standard. And then secondly, or actually thirdly, a great criminal defense attorney will want to make sure that his or her client has fair representation. Everything about the criminal justice system must be fair, and hiring a great criminal defense attorney can help you ensure that you get fair representation. So while you or somebody else might be worried about your case, withholding information from your criminal defense attorney can actually do more harm than good. But before I dive into that, let's first talk about attorney-client confidentiality. What is that? And so I want to help you understand that. Now, for attorney-client confidentiality, the general rule is that anything that you tell your attorney as part of your representation is confidential, okay? So you don't have to worry about your attorney revealing certain things about you in your case. So for example, if you say, yeah, I did it, now the attorney does not have to reveal that. In fact, he's precluded or cannot reveal that except for certain circumstances. And I'll get into that in just a minute. So now naturally there's going to be some circumstances where an attorney will have to reveal information. And one of those is called impliedly. If information is impliedly authorized as part of your case. So an example of that might be if there's an undisputed fact. For example, if you were driving a car at a certain time, certain place, and there's absolutely no doubt about that, that might be one instance in which an attorney can reveal that fact. Putting it in a different context, let's just use an example of a divorce. If you tell your attorney, well, I'm married and I have 3 kids, well, of course, that's going to be something that the attorney can reveal. He doesn't have to keep that confidential. That's going to be part of the divorce case. Another instance, we'll jump back now into criminal defense. Let's just say in a law firm there's more than one attorney, and you reveal information to one attorney, but he has an associate or partner that's also working on the case. Now that information that you tell that attorney can be revealed to another attorney within the law firm unless you specifically say, no, I only want you to know about this information. So those are some examples to the general rule where an attorney can reveal information. Now, there are some exceptions to the general rule. There's 6 exceptions according to the Oklahoma Rules of Professional Conduct. I'm only going to talk about 3 of those exceptions, and because those most apply to criminal defense. And so one of those exceptions is if you reveal information to your criminal defense attorney, and the attorney may reveal that information if he or she believes that, or reasonably believes, that will prevent reasonable certain death or substantial bodily harm to somebody else. So in other words, let's just say that a client comes in on an assault case, for example, and he says, yeah, you know what? I was in that fight with Jim Bob, and I really wish I would have finished him off. I'm going to take care of business. I'm going to do what I really wanted to do in the first place. I'm going to go to his house tonight and take care of business. Under that circumstance, an attorney may reveal that. He could call police, and he could even, contact the other person and say, I have information that my client was, says he's going to go do this. Because that's a threat or a reasonable belief that of certain death or substantial bodily harm. That's one instance where that could come up. It doesn't happen that often. It's probably really rare, but that's one instance where an attorney could reveal confidential information. Another one is to prevent a client from committing a crime, and I think this would have to be a serious crime. Obviously, if somebody says they're going to go out drinking, unless that person's going to go drive, he doesn't have to reveal that information. And there might be some instances where a client's going to commit a crime that might be lower level, nobody's going to get hurt, but that criminal defense attorney does not have to reveal that information to somebody else. He doesn't have to disclose that confidential information. And then another instance, and this is probably more rare in criminal defense situations, is an attorney may reveal confidential information if the attorney reasonably believes that it will prevent the client from committing a fraud, that it's reasonably certain to bring about some kind of substantial injury to somebody else's financial interests or the property of another. So those are 3 out of the 6 rare instances where an attorney can reveal confidential information. I'm not going to mention the other 3 because they're, in my opinion, really boring. They don't really apply to the criminal defense situation. I'll put that list of exceptions in my notes to this video, and you can read the article about that. So what if you're guilty? What if you actually did the crime that you might be charged with, or that you have in fact been charged with? So do you need to withhold that information? Or do you need to withhold it in hopes of getting a better deal, or maybe winning your case? For me, the answer is no. Now remember, criminal defense attorneys represent guilty people all the time. That's not a big deal. It happens. Now here's the deal. In my opinion, you should be forward and upfront with your attorney for a number of reasons. Remember, even if you are guilty, that's not the end of the matter. I've had many cases where somebody actually did commit a crime, but I've been able to get the charge dismissed. For one, you can file pre-trial motions. Maybe the charge hasn't been properly filed. There's a technicality. I've had that where I've had a charge dismissed because technically the prosecution did not file the charge right. There's all kinds of pre-trial motions that could potentially get your charge dismissed. There's like suppression, a motion to suppress, where evidence can be suppressed because it was illegally obtained. Even if you're guilty, the police might have screwed up. So that's one possibility of getting your charge dismissed. But it's still important that you be upfront with your attorney. Tell him all the stuff. Tell him even the bad stuff. There's no judgment here. Honesty is the best policy when it comes to talking to your criminal defense attorney. When it comes to talking to police, keep your mouth shut. Also, there may be certain facts that need to be revealed to get a good plea deal for you. Now, a plea deal can sometimes involve a little bit of jail time or prison time, depending on the severity of the case and the strength of the prosecution's case, or it could even involve getting probation. So, for example, if it's a drug charge, and maybe you're addicted to drugs, maybe it's some of the more serious drugs like methamphetamine or heroin, and you admit to use, and because of that, you're willing to go to drug treatment, and because of that, I'm able to negotiate probation for you. Probation meaning no jail time. You'll be out of jail. There'll be certain things that you have to do while on your probation, but it keeps you out of jail. Well, knowing certain facts, you being honest to me about that, and me revealing that to the prosecution as part of negotiation to get your probation might be necessary. And then secondly, or also, you've got to be honest, because I really can't effectively represent you unless you are. I don't need any surprises. It's not uncommon for clients to withhold information and then call me a week later and say, oh, by the way, I was afraid to tell you such and such. Or, it could be 2 weeks later or even a month later. Sometimes I even find out on my own through what's called a discovery process. I've forced the prosecution to turn over certain evidence, or found out through my own investigation that a client has hidden important, hurtful, damaging facts from me. Look, you've got to be honest. I've got to know everything in order to effectively represent you, okay? And again, like I said, tell me bad facts does not mean that you're going to go to jail or prison. I've just got to know all that information in order to effectively represent you. So generally speaking, even if you are guilty, tell me the truth. Again, there's no judgment here. My goal for you is to represent you in the best way I can to get the kind of result that you want in your case, the best possible result under the circumstances in your case. But I can't do that unless you're upfront and honest with me. So, if you or someone you know have been charged with a crime, give me a call. I'm Tulsa criminal defense attorney Stephen Cale. Give me a call at 918-277-4800. That's 918-277-4800. Your initial consultation is free. I hope you enjoyed this video. Take a look at the notes in this video and look at the article. It's more detailed. But give me a call.